My lord, urgently exceptional matters to be mentioned before this honorable court. There is a notice.
Is there any notice?
Yes, my lord.
We'll go to Honorable Chief Justice for that.
No, my lord, there is a notice to mention before your lordship.
Show me the notice.
My lord, we received in the group.
Very good. Exceptionally urgent matters.
Yes.
Very good. Maybe moved.
My lord, that is your lordship.
Exceptionally urgent.
Oh, this is exceptionally urgent, madam.
And that will see what is the meaning of maybe moved. Can you mention it? Or you have to get it listed here. Go and persuade the registry, get it listed, I'll hear it. Can I entertain the mentioning? I don't know. Can I?
Yes, listen. Registry can't ballot, sir.
Okay. What is the urgency?
My lord, this anticipatory bail application is a fresh admission matter. This was.
What is the offense?
Well, offense is a right case. And interim protection was granted till today, 12th. And the matter was directed to be listed in the week commencing 8th.
I'll extend it and
Grateful. Grateful.
reach 2 o'clock.
Grateful.
It's only for extension of time and
My lord.
matter.
My lord, that would do. Grateful.
My lords, I'm in the virtual mode, lordship, may I mention?
Oh, yes.
My lords, criminal appeal number 308 of 2011, lordships. My lords, the petitioner is 85-year-old lordships and his pension has been stopped due to the conviction since last 4 years. Lordship, I have been kind enough to list on 4th, but it could not be taken up. There is some arrangement by the...
Date already indicated.
My lords, it is indicated on 29th, lordships. May I play for 16th, lordships, Tuesday, lordships at 2 o'clock. It was already listed at 2 o'clock. It was put earlier, but it got adjourned by the state. 16th, lordships, may kindly accommodate.
Urgent to 29. 16th is the problem is 16th. There is no problem in listing, but it may not reach. That's
Then
the
my lords
problem.
may put it on 18th, lordships.
18th is packed, my lord.
18th, no.
Keeping in view all these
15th,
things,
18th,
my lord,
fixed,
keeping in view all this situation, we have kept it on 29 so that it could be heard and disposed.
once it is listed means it should be heard.
Then my lords may kindly prepone it a week earlier, lordships. Very
23rd?
small matter, lordships.
Can you try for 23rd?
May I know the number, please? My lords?
Oh,
308 of 2011.
308.
I
23rd.
need to check my diary actually.
My lords may kindly accommodate on 23rd, lordships.
1 minute, Mr. Samantra, you leave it to the court. We will see. See, the idea is once it is listed, has to be heard
Heard, yes.
and finish it up.
Yes.
Mr. Rizvi is also agreeing to that, but depending upon his this thing.
Lordship has specially assigned it at 2 o'clock on the 4th.
Yes, whenever it is listed, it will be listed at 2 o'clock and
Yes.
finish it up.
No, lordship, this month on the 4th, it is listed at 2 o'clock.
That's right.
It was adjourned. So, my lords may accommodate a week earlier on 23rd, lordships. My request, lordships.
We'll just see and
See.
fix it. Okay.
My lord, sir,
Grateful, lord, sir.
my lord, sir, yesterday your lordship has told me to serve some judgments on the delay part. I have got one judgment on the delay part, my lords.
Yes.
Yes, my lords.
Delay in 394.
Not in 394 specifically. Here the state has come up with a delay petition, but that was turned down by the Honorable Supreme Court.
Delay for what?
Delay in filing the SLP.
SLP, Postmaster General is there.
Yes.
That, see, this judgment is was kindly how will I express it? The judgment is hurt particularly me a lot because appearing in the SLP
Right.
in the state matter,
Yes.
everybody used to come with this. This is a very dangerous judgment for the
Yes,
state.
yes,
And on the basis, relying upon this judgment, many petitions were dismissed. Many,
yes.
hundreds of petitions were dismissed. Postmark.
But another judgment also I have taken out. I have the citation that is regarding the delay to be explained for each day. So that
No, that's there.
that-
But the only thing is in an application under 394,
specific.
whether it can be because the statute provides 30 days,
Beyond that,
Beyond that,
Yes.
can the court entertain or not? That's
most of the cases, it has been said that it has to be taken a liberal view
liberal view.
in order to have a
That's-
substantial justice.
That's
This is
Yes.
what I came across.
Yes,
My
sir.
lord, item number 25
Yes.
may be taken on next week, next Friday.
25.
My lord.
Okay. Not 14 wala. Next week. Well, this is against conviction.
Conviction.
Okay. Yes. Let us start. There is no other issue mentioned.
Item 1.
Both the cases have become infectious.
1 and 2.
No, one on the sub-item.
If a lordship permits, my lord, the second case 401 pertains to the import orders rejecting a discharge application.
So he
That-
says
Thereafter, he filed a 403 up to 710 challenging an order of framing charge.
don't go into. He
Trial
says
has been over and the petitioner has been convicted already.
Separate order कर देना. Then counsel for the petitioner submits that the matter has become infected. Therefore, the petition is disposed of. And is processed. Yeah. Memo is taken note of. Take.
Oh, bless.
Item 2.
Item 2, probably pass over, my lord, on behalf of Mr. Ponda.
Look,
I'll pass over.
Item 3.
Did I dispose of or wrongly mention as CRLMA instead of I?
dispute of
Dispose of matter, my lord.
modification that got inadvertently typed out
CRLMA.
allowed. Take look, modification allowed.
Item 4.
Yes. Cancellation of bail. Who is appearing for the opposite party? Notice? Not there. Let us pass over. Let us see. The ground is he was granted bail. Thereafter, he involved in 2 more cases. 2 more, other cases of similar nature.
No.
These are neither here nor there.
In the year 17.
Bail granted is 17. I'll give you liberty to apply the trial court to modify the conditions. That is better idea. Huh? Right down. The petitioner is the informant. You are the informant. Petitioner is the informant in the present case. He is challenging he is seeking recall of order dated 23/4/2015 passed by this court.
Yes.
Passed by this court. This court in a BLAPL number 873 of 2015 in connection to CT case number 37 of 47 of 2014, whereby this court has enlarged the petition, enlarged the opposite party number 1 on bail with the condition that he shall not involved in any other criminal cases in future. Subsequently, the opposite party got involved in 2 other cases. Through it. Although the offences are both the cases, subsequent cases are pending. Are pending. On that ground, petitioner is seeking cancellation of the bail. I am not inclined to entertain this application at this stage, at the belated stage. However, liberty is granted to the petitioner to move the trial court for imposition of appropriate condition, keeping in view the development which has taken place subsequent to the grant of bail to the opposite party number 2. If such application is moved, the same shall be considered on its own. And the condition of bail may be condition of bail may be imposed, taking into consideration all the attending facts and circumstances of the case. Yes.
Pardon, my lord. My lord, item 3, permitted to withdraw liberty to file a fresh application.
Which one?
Item number 3, my lord. Pardon, my
3.
Parasmestala.
Array, I already allowed. Correction allowed.
lord. I have
See,
no
correct.
instructions.
What you are saying is, in place of CRLMA is dismissed, and it should be
Miscase.
miscase. That's what you are saying.
Yes.
Why are you withdrawing again liberty? What is it?
Obliged, my lord.
You moved now modification application. I'm allowing it.
Obliged, my lord.
Why should you withdraw? Okay.
Item 5.
Yes. 5.
Cancellation of bail, my lord.
Ground.
Granted by the court below, my lord. Ground, my lord, the suppression of facts.
What
Obtain the
fact?
bail by opposite to by suppressing the fact, the injury report, and also others, my lord, injury written in the order are simple in nature. Paragraph 3, my lord, 4, my lord. Page 8.
Having heard the rival contention of the parties, and considering the period of detention in the country, there is no from what is the
The London Council submitted that there is a case and a counter case between the parties. Further investigation of the case has been substantially progressed, and the injuries sustained by the injured is simple in nature. So does it count the simple? That is
the submission?
My lord.
Then the court might have seen it. Right on. The present petition is filed by the informant in this case, seeking cancellation of bail granted to opposite party number 2 by the court below, by the order dated 21/3/2017. 2017. It is submitted by the non-appeals for the petition. It is contended by the petitioner in the present application that the opposite party number 2 has concealed the fact that the injury sustained by the injured are grievous in nature. I have perused the order dated 21/3/2017, where the Learned Council, the submission of Learned Council is recorded inter alia, stating that the injury sustained by the injured is simple in nature. That is not amounting to suppression of the fact. And moreover, since the bail has been granted on way back in the year 2017, I am not inclined to entertain this petition. Same be dismissed. Yes.
Item 6.
Pardon, my lord, I'm in virtual 6 infraction.
Thank you. Learned Council,
Obliged.
Mr. Acharya, Learned Council for the petitioner submits that the petition has become infracted. Disposed of it. Yes.
Obliged.
For it to not press item 7, my lord. Not press.
Not press. Very good. Learned Council for the petitioner submits that he doesn't want to press this petition. The petition is disposed of accordingly. See, all these matters are pending because it is never listed. These are burden for both the council as well as the court. Yes.
Item 8.
Yes.
Your notice issued, my lord.
What is this? Cancellation.
Cancellation.
Ground.
Ground, my lord. Here, ground, my lord, the threatened, my lord. The subsequent case, threatened. That is Annex 3.
Same order will pass. They will go to trial court. Bail granted by which court?
By the Sessions Court.
The petitioner is the informant in the present case. Petitioner is the informant?
My lord.
Petitioner is the informant in the case. Informant in the present case. He has filed the instant petition seeking recall of the order dated 22/10/2020, passed by 5 now. passed by learned ADJ come Special Judge Vigilance, Denkana in BLAPL number 318 of 2022, whereby the learned court has enlarged the opposite party number 2 on bail. Bail. Threatening, what is the ground?
Threatening, my lord.
Okay.
Other two cases instituted against him.
Non-appeal for the the petitioner has inter alia urged before this court that after release of the opposite party number 2, he has been threatening. Threatening whom? Witnesses or him?
He came to the house of the victim and
He
threatened,
has
my lord.
been threatening the victim. Therefore, he seeks recall of the concession of bail granted to the opposite party number 2. I am not inclined to cancel the bail, concession of bail granted to the opposite party number 2 at this stage. However, liberty is granted to the opposite party number 2 to move the court below for modification of the bail condition, modification of the bail condition, in view of the LA's threatening, LA's threatening to him or any witness by the opposite party number 2. If such application is moved, the same shall be ventured by the court below on its own merit. Yes. Let's go down.
Item 9 also concession bail, my lord.
Withdraw. 9. Memo. Take the memo, withdraw.
9 withdraw.
Withdraw. Yes.
Item 10.
My lord, I prefer an adjournment, my lords, on behalf of Mr. Mahapatra, my lords.
What is this matter? Let us see first of all. Again, cancellation of bail. Ground of cancellation.
Ground is taken only 11. There are many grounds the advocate has taken. 10 grounds, my lord.
My ground, I am not asking for
My
numbers.
lord,
You just tell
that
me
is the-
what is the real ground.
that has not been properly investigated.
Hmm?
Further,
I'll pass it over. I'll pass it over. Otherwise, I'll just give you the liberty to move the trial court for the variation of the bail condition.
bail has been granted by Hon'Ble High Court, my lord.
That's right. They can move the trial court. Tell all these things. High Court grants the bail. You want cancellation on the merits? It's not be possible. You go and challenge it
Yes, my lord.
because you are visually asking for challenging that order given by a coordinate bench. That for that you have to go to Superior Court, not here. Yes. Pass over.
Item 11.
May bail also. Here, my lord, the petitioner and 2 others have been convicted on section 420 and 417, 34 of IPC and sentenced to undergo RI for 3 years under section 420 and 6 months under section 417 of IPC.
See,
That I have preferred an appeal, the London Magistrate has passed an order. I have preferred an appeal before the London Additional District Judge, District of Contavan. The London District Judge has admitted my application, but so far as this petition is concerned, his bail application has been rejected on the ground that he was not on bail during trial. But so far as the other 2 co-accused persons are concerned, they have been allowed to go on bail because they were on bail. In fact, my lord, I was
What is the sentence?
sentenced to 3 years, and now I am in custody for more than 1 year, my lord.
No, this is what you. This is the.
This is the order. The
bail application.
The 389.
Essentially, this is the bail application.
389 application which is rejected by the London Appellate Court. Against that order, I prefer this application.
Yes.
The
Yes.
bail-
my lord, it's,
Why the other co-accused persons are granted bail? Appeal is admitted.
And
He has to be enlarged on bail.
Out of 3 years, I am in custody for more than 1 year.
Madam. Where is the order?
Order, my lord, that annexure,
Page number,
that is, my lord, the judgment. Annexure 1, page 9. Sorry, my lord, annexure 2, page 54, man.
Yes.
Annexure 2, page 54.
You have been convicted by the court.
Court of Land,
Right on.
JMFC Bangomunda.
Petitioner along with the other two co-accused persons, huh?
yes,
Lord,
Other two co-accused persons. Petitioner along with the other. You are Vivekananda.
I'm Vivekananda.
Petitioner and other two accused persons, namely Vinod Sahu and Bhairava Sahu, has been convicted by the court of JMFC Bangomunda in GR case number 81 of 2023 for alleged commission of offence by the judgment dated 12/4/2024 for alleged offence under section
And section 420, 417, or 34.
470, 34.
420, 417.
The accused persons were sentenced to undergo. Where is that?
That is, my lord. Annexure 1, page 9.
Tell me the
The
sentence.
ordering portion, sentence is 3 years, my lord. That ordering portion, the
To
sentence portion
undergo,
is as at
the
page 14.
accused persons were sentenced to undergo RI for
RA for 3 years
3 years. Substantive sentence of RI for 3 years.
and fine of rupees 10,000.
And fine of rupees 2,000 and default to pay.
Default to pay 5.
Default to undergo further period of
3 months.
3 months.
3 months.
Yes.
RI. SI.
This is RA.
3 months
RMA.
RI.
And under section 470, 6 months and 5,000.
For offence under section 470, RI for 6 months
6 months and 5,000 rupees fine.
and 5,000 and in default
In default, my lord, RA for 2 months.
RI for 2 months. Okay.
With the further direction, sentence program concurrent.
Against the said judgment of conviction and order of sentence, the petitioner as well as the co-accused persons have filed appeal, which has already been admitted. However, admitted. Insofar as the co-accused persons are concerned, they were enlarged on bail by the appellate court. However, the appellate court rejected the bail application of the present petitioner on the ground that during the trial, he was on bail.
He was not on bail.
He was not on bail. He was not on bail. Whereas the other co-accused persons were on bail. Petitioner is in custody since?
Custody since, my lord, once, pardon me. 1/7/2023.
1/7/2023. During trial also, he was in custody for
Custody.
how much time?
Since then, he is in custody.
Trial also, he was in custody. Keeping in view the period of custody undergone and the fact that the appeal has appeal against the conviction and sentence has already been admitted by the appellate court. I'm inclined to enlarge the petitioner on bail. The petitioner shall be released on bail, subject to the condition to be imposed by the appellate court also.
And the fine amount may be stayed, madam.
Fine amount he might have stayed.
No, madam, he has not stayed. Only on the ground that I was not on bail. So for other co-accused, there fine amount is stayed.
Fine amount he also paid. Fine amount you can go and tell.
In fact, my lord, he is a very poor man. Therefore,
Anyway, fine amount is also paid. No problem. Appeal is admitted, fine amount everything. Yes.
Item number 8. Appearance may be recorded only by appearance. Non appearance say lift deri gala appearance to record.
Yes, yes. You are for?
I am for to petition.
Yes. Artery petitioner. Dayanidhi Mishra.
Yes.
Item 12.
May I please your lordship? Petitioner is seeking extension of time. Order dated 13/5/24.
13?
13/5/24.
Page?
No, 13/5/24, your lordship kind of order.
13/5. Yes.
Your lordship have granted that he should surrender.
Direct to appear before the court below on 6 months, remove appropriate application.
In the meantime,
When do you want?
after 1 month from today, My lord,
15
he's suffering from heart attack and he's undergoing operation.
Okay.
and-
You've written all these things in the
My lord,
application.
I've given the certificate.
For the application IA number
IA number 1742/24.
1742/2044. By the order dated 15/5/2024, this court had directed the petitioner to appear oblique surrender 15/6/2024 and move appropriate application under law. Moved appropriate application and resort to the remedy available under law.
My lord, one more prayer.
For the reasons stated in the application, he could not surrender oblique appear before the
Ma'am.
court below
Ma'am.
and seek extension of time. Extension of time.
By 31st August.
Accordingly, the application is allowed and the petitioner is directed to appear before the court below on or before
31st August.
3 months.
No, this is July.
Okay, I thought it's June. Okay, 31st August.
My lord, one more.
1 week, 31st August 2024, and seek the remedy available to him under law. It is made clear that no further extension. shall be
One more
granted.
prayer.
Yes.
Clarity shall be maintained.
Parity, if it is there, it will be maintained. Why should I lie? Parity is there always.
ନ ଲେଖିଲେ ଆଜ୍ଞା ସେମାନେ କରୁନାହାନ୍ତି।
ଆରେ parity କୁଆଡେ ପଳେଇବ ନା କଣ? Parity ଯୋଉଟା ଅଛି ଅଛି।
ନାଇଁ ସେମାନେ କରୁନାହାନ୍ତି ଆପଣ ଟିକେ ଯୋଡ଼ି clarity shall be maintained ଲେଖିଦେବେ।
And learned counsel for the petitioner also submit that all the co-equal persons have already been enlarged on bail, so he is entitled to
Clarity.
parity. I have recorded your.
Madam, I know.
Number 13. What is the offense, by the way?
My lord, 394.
Yes.
So, order dated 17/11/2022. ये wrongly is my cause title 17/11/2023 में भी correct है.
This is item 13.
हाँ, NBW issued again 17/11/2022 the correct date. What is
Item 13 na 13 correction allowed. Correction कर दो.
अब extension time.
Acha, extension. In view of the aforementioned confusion, the petitioner could not surrender as directed by this court before the court below and seek a extension of time. Accordingly, time is extended up till 15th or 15th July.
15th.
15th पड़ेगा ना? July पड़ेगा. 15th August, huh? 15th August. 15th August. Exchange. Okay. 20th August. Because that 15th, that there are holidays and all, there will be confusion. 20th August. Okay. Item 14.
Item 14, this is adjourned to my lord 19th. Unfortunately, the matter has come today. Here is that the appellant, sole appellant died. The widow, my lord, want to contest the case. My lord, to that effect, 2 IA has been filed. In the second matter, my lord. CRLA 151 of 2006. So far as first matter is concerned, my learned senior, her senior, my lord, want to file an application to contest the case, the widow.
Want to file, it is already abated now. I abated you whenever
No,
you
your
file.
lordship directed, I have filed, my lord.
Directed.
My lord, I have filed. In my case, my lord.
The second matter you have already filed.
My, in the
And
first matter, my
If they
learned.
don't file, then it will be abated. And they will have to move an application for setting aside abatement and all. I can't keep on waiting till you file it. As of today, the appellant has died.
19th को hitala, it unfortunately the matter has come today.
I'll
If
file the
nothing has come,
application.
the matter adjourned on 19th.
How it has come now? Yes. These are the matters I tell you. I have heard one of the connected matters yesterday. So
Right.
therefore, I asked him to list all other matters. About 9 matters were there. I found when I was trying to dictate the order, I found a slip. There are about 9 matters, connected matters.
Sir,
One matter has already been allowed, and other matter I have heard. if I'm not wrong. Yesterday, the one that horticulture thing and all.
Yes, my lord.
There I found a slip
My lord.
supplied by the prosecution itself. There are 11 matters.
One tier case, my lord, several cases.
There are 11 matters.
And in that case, this will be all
So therefore,
covered.
I thought let all the matter be listed. So we can see what is item 14, 14, 15, 16 and
No, these are all different matters. My lord. 34, 35, 36, 37.
but I got in the file
That might have been
given by you people only.
it might have been misplaced, my lord. Otherwise, these are all different matters. My lord.
Let us see if it is different, then it will come at its own court.
Own course, yes.
But if these are connected matter, I thought all the matter can be disposed of. Why unnecessary 11 matters are pending? That is the reason I asked him to.
Oh.
Let us see what are the cases here. Just 1 minute, I'll let them do.
My lord.
Let us see what is this case. No, these are national textbook, Mishra profession and all.
Different.
This is not the same. Why have you given that slip then? Let us see. And 15 also.
My lord, I think
Anything to
on
do
that
with
relevant day,
horticulture thing.
yeah, that is a different matter. My lord.
This is not the
This is
same.
not connected.
What did that slip worry that get that file? That is in my table.
I think
I
that
was-
that would have been the cause list of the
No, no,
My lord.
no, no.
Handwritten slip, my lord.
Yes. Connected matter is written there.
Oh,
And you people have filed. Some your predecessor might have
Yes.
filed. Whatever looks better. Then put, what we'll do is we'll put it all these matters in weekly.
weekly, yes, my lord.
All the
Yes,
matters
yes.
are listed. I'll call one after another. We'll see. We'll see.
Yes.
This is regarding
14.
what?
This is 14.
This is 14, my lord. This is regarding, my lord, conviction. 1 year conviction for the offense under section 13(1)(c) in 13(1) of the PC Act and 409 and 34. And my application.
See, this is a common note you had given in all these matters. Common submission. I thought, therefore, it is give it to Mr. Rishi. I thought these are common.
Common.
This was given by the prosecution.
No.
So all these matters, I thought.
Lots of cases correct, but I found that signature for another council lots was not in the
We are
panel.
extremely
No,
sorry.
not in, I am not,
Yes.
your predecessor,
Yes, ma'am.
whoever
Yes,
may be.
yes, that's
So
correct.
I thought all these matters are connected somehow, so I can dispose of all the matters. Because I am going to dictate the other judgment.
Approach is, yeah.
Was
All are
extremely-
different,
I was extremely sorry for the trouble. My lords.
so all are not same then.
All are not.
So 14, you put it in weekly list. Huh? Let us see, still we will go
One by
after
one,
another.
yes.
Checks. 14, I'll put it in the.
Yes.
15. That's gonna ban-
Sir. There is no instruction from the,
Yes, sir,
there is no instruction from the appellant.
no instruction.
No.
My lords,
So-
in fact, this matter has been stands adjourned to 18/7, so we can wait till 18.
18?
18/7. This is
Acha, 18/7, okay. 18.
Item 16.
In this case, the IA for substitution may be allowed.
Have you filed it?
Yes. IA 1756 of 19.
1756, huh?
Yes.
Right.
That is 2013 for grant of leave to legal heirs to continue the appeal.
2013.
13.
I think on 1/7/24, your lordship has already allowed.
I will allowed.
Lordship, may kindly peruse the order dated 1/7/24.
And then limitation is condoned. I don't know why it is again today. I was of the impression that is also allowed, but anyway, let us see.
No, it is because of the same confusion. 17 also, na? Ah, okay, same confusion. Because I thought it's a connected matter. Because
Oh.
I got that list from one of the files while giving dictation. The prosecution had filed, these are connected matters. I thought the connected matter list all the matters.
Our records may be verified if it is not connected.
I have verified it. Let it come in the weekly.
Weekly, yes.
Weekly.
Another thing, my lord, here, your lordship, so far the paper book is concerned, probably he was interested to hear, to take up the matter on merit when he was alive, the appellant. So there is some defect in the paper book supplied by the appellant. So I pray that the office may be directed to prepare authenticated paper book within a particular.
We'll do that.
Specified.
We are following a procedure. Don't worry. We'll do that.
Because they probably, now that legally are not able to find a authenticated,
Right.
again there will be mistake. So the office may be directed with their duty
Yes.
to prepare the paper book.
We'll do it. Weekly list of them. Weekly.
It will come on
Weekly.
weekly.
It will be
Any day.
included in the weekly whenever you are. Yes. 16 over.
17, lordship, in item number 17, there is an arithmetical mistake in the judgment, impugned judgment.
Mhm.
And if that arithmetical mistake is corrected, the appeal will be allowed. May I
Not
place
that-
that? There will be no dispute between the state and
It's a
the
DA case.
appellant, DA case. There is only an arithmetical mistake in the judgment, impugned judgment.
Let us see if that.
No, that is
Let
not
me-
the,
let me
that,
praise.
that simple the way he is projecting.
No,
There are
let
so
me
many
praise.
pleas he has taken, that is one of.
Let me praise it. Let me praise it. If I can satisfy the court,
Hearing have
all right. If I cannot,
It's a calculation. It's to be hard.
No. If
no.
there is a typographical error.
arithmetical mistake.
Typographical error ହେଇଛି,
Hmm.
that benefit should not be extended at all.
No, I'm
Let us
pointing
see,
out.
one
I'm
minute,
pointing out.
1 minute.
1 minute.
1 minute.
Lordship, may kindly come to page 29 of the paper book.
Paper book then. Paper book. Twenty.
29. Savings from income in pre-check period.
1 minute. Yes, 29. Yes.
Lordship,
Saving from income.
in
in
pre-check
pre-check
period.
Okay.
It is interesting to take note of the fact that according to the prosecution, the accused had worked as a lecturer for a period of 7 to 8 months in the year 97. That is till he joined in the service as sub-inspector of police on 1988. Born on 1970, he became major by 1998. The check period is from 1 month 2002. Income, if any, in the pre-check period as a government servant, prior to that as a lecturer, and prior to that as an eligible bachelor was not considered explicitly by the prosecution in the charge sheet. When the defense has claimed savings from income during pre-check period as rupees 2 lakh, in the argument of the learned special PP vigilance submitted that salary received during pre-check period was taken into consideration, and after adjusting the possible expenditure in it, the net income is taken into consideration in final calculation of disproportionate assets. It is argued that though it is not mentioned with details about the possible income and expenditure and savings during pre-check period, but in the final calculation was taken into consideration, the argument is not conceivable as it is bounden duty of the prosecution to specifically mention about the possible saving during pre-check period. Conversely, the defense has failed to substantiate the savings from out of the income of the wife of the accused. It is claimed that the wife of the accused was earning from private tuition. She had given money to her brother-in-law for investment in brick kiln, and in return her brother-in-law repaid it to to the extent of rupees 80,000 to 90,000, including this amount of the defense claimed the pre-check period of rupees 2 lakh. Accused person became major in the year 1988, joined service of a lecturer in the year 1997, and worked as such for 7 to 8 months, and thereafter joined in the government job in the year 1998, but opened his bank account only in the year 2000. From these, a definite presumption can be inferred that he must have some savings with him from his earnings. Therefore, looking at the average range of the income over the check period by the accused, we can determine the saving during the pre-check period as follows. Out of the income of the accused during pre-check period from 1/1/2002 to 25/7/2006 is calculated at rupees 5,20,598. The prosecution has shown the income from salary in 5.5 years at rupees 4,49,804, which remained undisputed. Accused joined service in the year 1998. Taking cue from the above on the basis of income under salary head, his income from salary, including the period worked as private lecturer for 4 years, calculated at rupees 3,27,130 till 1/1/2002, and the modus operandi is in the bracket 4,49,804 divided by 5.5 and multiplier of 4 is equal to
which figure according to you is
Lordship, herein is the mistake. What has happened? The period is 4.5 years and the division is by 5.5. Lordship, got it? The first two lines from 1/1/2002 to 25/7/2006. Lordship, got it? It is a period of 4.5 years. What the court has done has taken it as 5.5 years. So if it is divided by 4.5 and multiplied by 4, the figure is different.
How much it comes? Have you done it?
Yes, yes. What has happened, Lordship?
How much it comes?
I am telling Lordship. I am in the note I have mentioned the figure is exact figure I have mentioned. The differential amount comes to rupees 50,000 and odd. DA is 16%. If the differential amount is made minus, the DA comes below 10%, and there is no case. So what is the dispute? This has not been challenged by the state. This finding of the learned trial court has attained final.
Thing is that
it should have been 3.5.
3.5 हवा कथा 4.5 हवा कथा से 5.5 नहीं चलते. That my submission is when there is no income at all during the pre-check period. So question of giving benefit.
No, these are the findings that there is income. You can't.
That finding can, your lordship can interfere in under section 386.
His appeal. You can't argue otherwise.
Your lordship can also interfere under section 386.
See, but there is a concrete finding of fact that there was income. Okay, the division should have been 4.5, admitted.
There was income. My submission is, lordship can visualize. My submission is, there was income, he was serving as a lecturer in private college. When we take the check period, on the beginning of the year, check period, there was no saving at all. Hence, it is presumed that the money he has earned has been spent. We have not taken any assets or expenditure or any income during the check period because there was no saving at all.
No, that was the prosecution case, there was saving.
There was saving. There was not saving. There was income, but no saving at all. Since there is no saving, giving benefit of saving.
What your charge sheet says?
Madam?
What your charge sheet says?
Charge sheet says so. We have not taken that period income.
Not at all.
No. So that's why I submitted. Apart from that, he has also taken the other pleas. That's why I have submitted. It requires a thorough hearing. It's not that simple. It is calculation or that.
Lordship,
when there is no head, there is question of the headache does not arise.
Lordship, let me reply to his submission. The the appellant accused was working as a lecturer in a private college for 7 to 8 months. Prior to the check period. 7 to 8 months. Thereafter, he joined the police service. And for police service, he worked for 4 years and 4 years, around 4 years. And during that period, he was on probation. The evidence led by the accused appellant is that since he was on probation and he was on training, he was staying in the hostel, his wife was with his parents, whereby he had not to maintain his wife, and he had much more savings during that period. And the learned trial court, on analysis of it, the well-established principle of law is that, as laid down by the Honorable Apex Court, is that when you take a part of the service period as check period, and the person has served prior to that also, then the prosecution is bound to give a reasonable amount towards his pre-check period savings, which, and this the prosecution had not done in the instant
that
case.
You tell me when can we fix it?
As usual here,
I don't think
2019.
it will take much time.
Not much time.
If Lordship will permit, you notes they do. Your Lordship may go through and pass up.
No, not.
Because
cases I have to see.
it said it requires a thorough calculation and a hearing.
So therefore, you tell me date.
As usual course,
Next
weekly list, weekly hearing.
Weekly hearing,
Null 20.
नहीं orders रहे था
23rd August 23rd August
orders रहे ही
Super
dispose of
Friday
pay you orders रहे ही dispose of pay you
Orders रहे नहीं 23rd August
He has all objections. What?
23rd August
Otherwise, on this ground, if you consider this part,
then
no, set up the move fast initially.
Lordship,
I was under that impression with good faith, but when I go through the
by the way, you
notes
were a
I
lecturer. Why have you left a good job and came to this lucrative business?
that I cannot say. That I cannot say. For your Lordship's kind reference, I too was a lecturer in UGC scale.
No,
I resigned and came to came to the profession.
To serve people, you are doing that.
And prior to that, I was working as a sub editor in National Daily. That I resigned, I joined as a lecturer.
People are getting advantage of your experience and all in the bar.
Let's see.
Because of your experience and all.
23rd August as well. 23rd August.
No, he will adjust the date accordingly. He'll give an intimate. He'll adjust a date so that at 2 o'clock I'll hear it.
Lordship, date fix kar
Date adjust करके ticket हो जान तो से
कौन तो date
देखी कर दे बेसिक. You just just check it up.
Don't get a Friday route. If I'm going to छुट्टी होते हैं दिन कर जो.
नहीं सी करी रुहन तो टिके बेसी मैटर लिस्ट कर देला को होई पड़नी. Please contact.
September was.
But this will
at
not
2
take
PM
much
कर
time.
देवे.
Move daily calculation करा. खाली ये Lordship to interview करा किसी रहे.
Don't try to improve your case in his appeal.
नहीं मुझे सेट improve करूँ नहीं. किंतु सेटा income नहीं है जिससे कोई saving. Income saving, there is difference between income and saving.
Yes.
Item 18.
My lord, in this case, I have prayed for change of nomenclature from criminal revision to criminal appeal.
So this is pending since 2020. What is this matter is about?
Lordship permits, lords. My learned friend has preferred this revision, lords, against an ordered, lords, passed by the learned special judge, special court, Bhubaneswar, lords, against an order by which, whereby his application for decision has been rejected, lords. And my lord, my humble submission for lordship, in fact, my learned friend is aware, lords, under section 9 of the Special Court Act, lords, this order is neither revisable nor appealable. But my learned friends may be inadvertently filed this application, which is appended this particular the cost item, lords, that IN number 676 of 2021. He wants to change the nomenclature or the convert it to criminal appeal. But I'm sorry, my lord, I'm afraid it may not be possible because if lordship permits, my lords, if lordship can Go to that page 30, the top books, Lords.
Page 30.
Page 30, my Lords. My Lords, we turn to rule section 9, my Lords, subsection 2. I hope you Lordship got it.
Yes, yes, I got it.
Except as aforesaid, no appeal or revision shall lie in any court from any judgment, sentence, or orders of a special court. And here the impugned order has been passed by special court. So this is neither appealable nor revisable. But they are not remediless. They can file. They can file writ criminals.
482. 227, 480. Then counsel for the petitioner seeks to withdraw.
Basing on my oral prayer, Lordship may change it to 482.
Now the e-filing is there. No, that's why.
Let counsel for the petitioner seeks to withdraw the present petition to avail appropriate remedy under law. With this liberty, the petition is disposed of. Yes.
Obliged.
19.
Appropriate.
19 may come next week. Let me find out what is the status of
I agree with my Lord Senior. The reason being, Lordship turned to page 17, my Lords. Against an order framing charge, my Lord, this revision has been preferred.
No, the revision is basically not against an order framing charge. It is on the basis of a petition which I have filed, having not been considered, which I have annexed at page 31. In any event, let it come next week. I'll find out this.
Next. Yes.
Item 20.
Item 20, Lordship, on behalf of Mr. B.S. Das, Lordship.
Yes.
May call this matter next week.
Huh?
Your Lordship may call this matter next week.
What is this matter? You do you have the file with you?
No.
I'll pass it over. You just come with the file.
If Lordship permits, my learned friends in the early morning has been pursuing this matter with me also. This is just.
I'll urgent, but without file he has come.
No.
He should read it.
No, why, what I suggest, this is a state revision, my Lord, against an order of conviction. And
against acquittal.
Yes, my Lord. She was discharged.
Discharged. For the same issue.
But though line the so
it's all right.
Let it come.
I kept the other matter when for this discharge thing.
Two matters are there. Monday also muta.
No, kebe lagoi thili.
Kebe upon seta.
No, not Mr. Rijvi will tell you. Mr. Rijvi, against discharge you filed revision in two matters.
Oh, yesterday's matters.
When it is reached.
Yes, it is coming on
Tuesday.
Tuesday. Keep it.
16/7. Sorry. 16/7. 16/7.
It's a Tuesday.
I have done some homework in it.
We are grateful.
Obliged. Yes.
21.
This is item 20 to 12.
16. 21.
21, I am for the opposite party. 138, and he has been taking time on the ground that matter is, there is a talk.
You are for opposite party.
Opposite party.
Check amount.
63,000. And he's, there is no such stock.
None APS for the petitioner. 63,000 rupees. You are since 2012 you are prosecuting the case.
Concurrent finding of facts.
He might have spent more than that prosecuting this.
And the council engaged.
Item 21, I am there. Item 21, I am sorry, madam. Item 21. This is a 138 conviction matter where I took time for settlement.
Mr. Mishra, it is 63,000 check. Check of rupees 63,000. 2012, after conviction, this matter is pending.
May I just clarify on that? I am not praying for time. What I am praying for, this opposite party, my lord, agreed for a settlement initially when I made an attempt. He is somehow not coming to the table. I am only praying for your lordship may send it to the mediation center. It will be settled. I am ready to pay.
65,000 plus 15%. How much?
15%, your lordship.
Yes, 15% of check amount. This is the judgment of Supreme Court. What to do?
My lord, your lordship may keep it to next week. I will take instruction on that. It will be said. I am ready to pay.
You come with a check of 70,000 rupees.
Yes,
Monday. Come with a
where
draft.
is that? My lord.
Come with.
Your lordship may not indicate in the order. This is the my
I'm
lord.
not indicating, but I will not forget also. Till Monday, I will not.
I owe a duty to your lordship. I am an officer of the court. I have to assist your lordship, my lord.
70,000 rupees draft, you come, otherwise I'll dismiss it.
Deeply grateful. Man, I know the limitation because I have lost in 2 forums, my lord. So I want to settle.
You also take it 70,000 to put an end.
I am bringing it next week, my lord.
Monday, sir.
No, Monday. Your lordship may keep it to Thursday or Friday.
Tuesday.
Thursday रहोगे ना Monday, Tuesday dita से part had
No,
hearing.
I have my own limitation. After 3 days, I forget. That's the problem.
My friend is there for the other side, and I am an officer of court, my lord. I have to point out, my lord. Your lord.
Wednesday.
Thursday Wednesday was the छुट्टी अच्छी. Thursday रहो. Thursday रहो मु definitely नहीं किया क्योंकि ना Monday, Tuesday दीटा part had top रे रही है इचे अन्य court रे.
Okay.
अब मु निजे personally attend करिया उठाऊँ चाहिए आउ किसी कारण नहीं.
Mr. S.K. Mishra, senior counsel for the petitioner, seeks an adjournment to ensure that the matter would be settled by the next date of hearing. It is made clear that the matter is adjourned to Friday, and no further adjournment shall be given. If the matter is not settled by Friday, the same shall be, the matter would be heard on merit without entertaining any request for adjournment.
Grateful, my lord.
Right.
And it's a matter, I always,
draft.
Whenever I get a chance, I appear before your lordship because I don't want to miss it, man. So therefore, I said not Monday and Tuesday.
Thank you.
Only because of that.
Thank you. Yes.
Right, man.
Yes. 22. Same.
No matter. That is 22,408.
That's a 408. Convicted, huh?
Convicted for 2 years, 5 months, 5,000. Appeal dismissed.
Nobody appears.
And on that day, in 2012, the appellant was 45 years.
2012, 45 means now?
It is 85.
Huh?
85. Was a salesman in the cooperative land. Cooperative cell. The misappropriation amount is 5,806.
What do I can't dismiss it unless it is ascertained. You tell me which police station. Let us give a direction to the IIC.
Kodinga in Nabarangpur district.
Nabarangpur, huh? Nabarangpur. Kodinga village. Kodinga. Kodinga PS. PS Kodinga. Non-APS person. You are a P. Yes. What is the status? See there. He is 85. See, 45 years he was in the year 2000. No, in 2003 he was 45 years.
And in 2012, when the petition was filed.
No, you come to page 7. Trial court judgment. Trial court judgment, if you come, Anirudh Majhi.
Yes, sir.
Is about 45 years. That is in the year 2003.
I have to take it soon next 2 years.
So he may not be 85.
More than it.
More than it. Okay. During the trial, then from the trial court judgment, it appears that the petitioner was 45 years of age in the year 2003. 2003. That counsel for the petitioner submits that he has no instruction regarding his well-being and whereabouts. He seeks 1 week time. In the meantime, IIT PS Kodinga, district Nabarangpur, is directed to inquire about the well-being and whereabouts of the petitioner and place a report by next date of 23. 23rd.
Okay.
Free copy. Give free copy.
Item 23.
My lord was pleased to direct.
Yes, sir.
The petitioner to deposit 15,000 because the last occasion, my lord, I had submitted that at the stage of admission, 1 lakh was paid, and that was the amount.
Ordered, my lord, that we had received the amount on 3/1/2014, 1 lakh. And with regards to 15,000, I have also prepared the draft, but they have not received it. If my lord friend, I prepared the draft with the name of the complaint.
It's all right. Yeah, we'll take it up and close it. And you give it to your junior, sir. Let him come. I'll pass it over. I'll just give it. Otherwise, that is really, the draft will be trouble for us. We'll give the draft and close it.
The original is not with me. I have got the Xerox with.
Original is.
Original will be received by the complainant there. Or if my lord friend will receive it, I can collect it.
I'll pass it over. Let us see and dispose it.
I've got the draft as per.
Pass it over.
Madam, in this case, hearing was completed before another.
What is the prayer? What is the matter?
He was convicted for 2 years and the penalty of 15 lakhs.
15 lakhs.
14 lakhs.
14 lakhs.
Madam, we have
Appellate court modified the order. Probably it was 15 lakhs. Highly displaced by some amendment necessary.
My lord, we have also filed a revision for inadequate
Yes,
sentence.
yes.
Both are
In
kept.
first case, I am for the petitioner. In second case, I am for the appeal.
So are you going to settle or what? What do you?
He is not entitled to get.
You are convicted by 2 courts now.
Appellate court said that accused has no capacity to pay. That is the observation and the appeal was dismissed.
I have challenged on 3 doubts. Main ground is my lord, statutory notice is not sent to the complaint, to the accused.
Not sent or not received?
Not sent, my lord.
In the complaint, it is
My
found.
lord. And another is company is not made a party. Notice issued by the director, one of the directors of the company. Company is not made a party.
Check issued by one of the directors.
One of the directors.
Yes.
And another is my lord, no legally enforcing test. That is my.
So that's a different story.
All
But
those
how will
things-
you get out of this two vital points? If
My-
you don't give statutory notice under 138, then the complaint is not maintainable. And second is company is necessary to be made a party. That's the law.
My lord, I will explain. If my lord friend says that he wants 1 week time, I will explain.
No, you explain these two things. See, the Supreme Court has recently also said that unless you implead the company, you can't prosecute the director simpliciter.
My lord, the fact and circumstances of present case is little different. I will come ready in the legislature. I have given written note of argument since long, memo of citation since long. I have to go through my file, what my lord friend says now. Now,
Within a week I will have.
I'll put it next week. There is nothing in this one.
1 week.
If these two things are correct, then it has to go. The conviction has to go. If these two things are correct.
yes,
then
your
have to
lordship,
verify.
I am conscious. I have explained all those things in my written note of argument.
Earlier regime was different. Earlier one judgment was there. It was the view of the Supreme Court. Earlier view of the Supreme Court is without company also you can prosecute. And the view is reversed thereafter. Yes. The view is
So my lord, on the next date, next Friday.
one of the matter I appeared also that is a reported judgment Supreme Court. Same issue.
Yes. So 1 week after my lord, on next Monday. 1 week after on next Monday.
23rd.
23rd.
23rd at 2 o'clock.
2 o'clock. ma'am.
A joint request, leaves the matter on 23rd at 2 o'clock. At 2 o'clock, it is made clear that no further adjournments are required. Yes. Still, if you want to settle, you can settle. But he doesn't have the money, what to do? That's the findings. Yes.
26.
May I please your lordship? Your my lord, both
What
petitioners, both the petitioners, my lord, have been convicted of offense under section, under rule 21 of the Orissa Timber and
other forest transit rule 1980. In carried appeal also that judge, the order passed by the London Trial Court has been affirmed. So I pray, my lord, let the discharge on PO.
Sentence, how much?
3 years.
3 years. Appeal confirmed. Incident?
2012.
Yes, what do you say? He's confining his argument to the quantum of sentence.
My lord.
He's not questioning the conviction.
My lord. Petitioner one is the my lord occupant of the vehicle and two is the driver.
No, forget about that. He is not questioning on facts. He is only quantum of sentence. In the quantum of sentence, what do you want to say? He says that grant the benefit of Provision of Offenders Act.
My lord,
In these kind of cases,
let him
can
go,
we
my
give or can
let him go.
they are entitled or not? You ask it there.
My lord, let him go. You are.
I'll record your concession then. PO 40. Have you prayed before the court for PO? Yes. There is no legal bar. Yes, Mr. Raghunath, is there any legal bar? No legal bar? Timber, what is the offense is?
Forest Act. Forest Act, my lord.
Forest Act. There is no legal bar, na? There is no legal bar, Mr. Then grant PO.
Please, your lordship.
Lord, may I submit one thing before my.
Because the many special statute, there are
Yes,
legal
yes.
bar.
In the Forest Act.
Forest Act, no.
Item 27, Lords. Here the name of the petition is Prabhakar Naik. Same petitioner, item 28, 29, Lords. I believe in 1-2 matters, I was the counsel and similar matter has been disposed of. But what I suggest, my Lord, if Lordship see the item 27, my learned sin has rightly has appended the similar situated cases, judgments at flag C and D, my Lords. What I suggest, my Lord, I could have get it from the department, but because I have accrued some right over my elder brother, Mr. Panda, a copy may be given to me and 4 cases can dispose of. Because I know the petitioner's name, Lords. I faintly remember I conducted 1-2 cases of the same cases. Just I'll go through the judgment and I'll come back to your lordship on Monday. So all 3 cases can. If there is a factum of similarities there, I'll come back.
He might have appeared then.
Yes, he was appearing in fact. In fact, he was appearing.
Then I'll record Mr. Rajiv. It fall in his head. Fall in his head and allow it.
Mr. Das is for the vigilance.
I'll just go through it. I'll assist your lordship.
Monday?
Monday.
No, not Monday, Tuesday.
Tuesday.
Tuesday. Okay. So all the 4 matter can be disposed of.
I believe you rely this judgment on all cases.
27-28
Kuntia, I think you share with us, isn't it?
At least 3 matters will be over. Yes. Tuesday, huh? Tuesday. Please verify on Tuesday so that. Shall I keep it at 2 o'clock? It won't take much time. It's covered judgment.
2 o'clock.
Covered judgment, why? Yes. Let it come.
2 o'clock.
2 o'clock or down.
2 o'clock. No, 2 o'clock already there. Because no hearing is required.
My lord, 2 o'clock after that matter, it can be taken up. It will take 5 minutes.
2 o'clock.
Besim basiya pude. 18 thau na. 18
ନାଇଁ ଏଇଟା ଥାଉ ଏମିତି ଲଞ୍ଚ ଆଗରୁ ହେଲେ କରିଦେବା ନହେଲେ 2 o'clock କରିବା let it be I don't think it will take much time because it is already covered. Already it takes judgment. Hmm? Simply adjourn कर दीजिए.
Lord, here the petitioner before my lord has been convicted for the offence under section 379 of IPC and has been sentenced to undergo RI for 2 years, my lord. My lord, if your lordship will go through the evidence of PW 2, 3 and 4.
Right, 29?
30, my lord,
30,
30.
my lord.
Yes.
379 is the offence for which the petitioner has been convicted, and for 2 years he has been sentenced to undergo, your lordship. If your lordship will have a glance to the evidence of PW 2, 3 and 4, and they have categorically stated that in their examination in chief, hearing Halla, I went to the spot and found 8 iron angles have been caught and 2 aripatis and 2 motorcycles were there. We found the accused persons and the villagers at the spot. But in the cross-examination, all 3 have stated that I have not seen who caught the angles and how they were caught. This is my first contention. Secondly, my lord.
Now repeat it. First contention, once again repeat.
My lord,
Let me understand.
here, PW 2, 3 and 4.
30 na? PW 2, 3
And 4.
Yes.
They have categorically stated in their examination in chief that hearing Halla, I went to the spot and found 8 iron angles have been caught and 2 are.
PW, yes. PW 2, 3.
2, 3 and 4, my lord.
2, 3 and 4. What have they said?
They have stated in their examination in chief
Hmm.
that hearing Halla, I went to the spot and found 8 iron angles have been caught and 2 aripatis and 2 motorcycles were there. We found the accused persons and the villagers at the spot. But in their cross-examination, they have clearly stated that we have not seen who caught those angles and how they were caught, your lordship. This is my first contention. Thereafter, my lord, PW5, who is the informant. PW5, who is the informant, he in his examination in chief has clearly stated that hearing Halla, he went to the spot and found another co-petitioner, namely Premjit Singh alias Gaju. Premjit Singh alias Gaju was apprehended from the spot, your lordship. The present petitioner was not at the spot during that occurrence. And subsequently, he has stated that thereafter all the accused persons went to the village by motorcycles, and we could know that the present petitioner was also involved. That means there are material contradiction between the statement of the informant, evidence of the informant, and the witness to the occurrence, your lordship, PW 2, 3 and 4. And that apart, your lordship, thirdly, I would like to invite your lordship's kind attention to the evidence of PW 7, who is the IO. IO in his examination in chief has stated that informant Narayan Ponda, that is PW 5, he was not chowkidar of that particular spot at the relevant time. There was no chowkidar appointed at irrigation guest house, but PW 5 claims him to be the watchman of that irrigation guest house.
Yeah.
And that apart, the IO has also stated that he seized 2 motorcycles, 8 number of iron angles, and 2 aripatis from the accused persons. But that symbolizes to the apprehension of Premjit Singh alias Goju, who was apprehended from the spot by the villagers.
What are the stolen articles?
Only 8 iron angles.
Iron?
8 number of iron angles.
Angles.
And that Aripato.
Aripato that was used to cut. They have stated, say, Dita Aripati or 8 iron angle. It was on the spot itself, along with 2 motorcycles, which were used in the occurrence, that was seized by the IO from the spot.
And that alias motorcycle belongs to the petitioner, my lord. That petitioner, my lord.
Petitioner was not apprehended from the spot, from which is evident.
There are two petitioners.
There are 2.
No,
here the petitioner is 1, but 2 accused persons.
One of them is acquitted.
No.
Where is the other one?
Initially, trial started from one accused who that the said
What happened to Paramjit Singh?
My lord.
What
Paramjit
happened,
Singh, my lord.
Paramjit Singh?
Paramjit Singh, my lord, it is that he has been convicted, my lord.
He has also been convicted, but whether he has deferred any.
No, in the year 2004, he was 45 years old.
My lord.
Has he died or what?
My lord, that instruction.
Appeal preferred by both of them,
Appeal preferred by both of them, and appeal was confirmed.
and thereafter he has not filed any.
Thereafter, we are not counsel.
Are you sure? But is there another revision pending?
That accused Robbie Bagh, my lord, one of the accused, he has been convicted and sentenced to undergo RI for period of 5 months and under section 370 and 34 IPC, my lord. That the 3 persons faced their trial jointly, my lord.
Jointly, and Robbie Bagh admitted his.
So for Ganesh Maji defaulted and he could be apprehended, and that NBW has been issued against him. One my lord, one accused, Ganesh Maji, absconded accused, my lord. Thereafter the case was split up and
The appellate court ordered.
my lord,
The appellate court.
the Law and Trial Court, my lord, observed in his judgment, my lord.
Yes.
And the petitioner was in custody for 4 days. That is from 16/1/2004.
Only 4 days.
Only 4 days, your lordship.
Are you aiming at acquittal?
As your lordship deems
No,
fit and
if you are thinking that you have a good case on acquittal, just point out to the contradictions, apparent contradiction. See, there are 3 eyewitnesses according to them.
PW 2, 3, and 4.
2, 3, and 4, and 5 is the informant.
5 is the informant.
And you have to point out. You have to point out what are the contradictions. Properly point out. And prepare a small note and give so that we can see if you are aiming at acquittal.
PO Act, your lordship may consider.
You
For 4 days.
PO कर दिया.
Your lordship should not allow.
Huh?
Mr. Dhar from behind is suggesting that. He should learn, my lord.
That's
What
right.
Your lordship is suggesting, that is for him. If Mr. Dhar was appearing, then you have to.
So what I'll do is I'll allow you PO subject to you arguing for the matter full. Okay? And prepare a note and come Tuesday. Okay? Tuesday, try for an acquittal. You may have a good case for acquittal also. Don't go shortcut.
Say for Thursday, your lordship, Tuesday.
Thursday, okay. Thursday.
Well, in the meantime,
18th. Huh?
18th.
Thursday, 18th, Friday.
Let it be on Friday.
19th, your lordship.
Prepare
I
a
will
note
prepare a
and
copy.
come with the contradiction.
Obliged.
Because this is a appeal revision pending since 2011. And at the time when the offense was committed way back in the year 2004. That time you were about 22 years old. Now you might have been settled in your life unnecessary, getting you jail. No. And but see whether he's working, is a government employee, whatever. You just check it up. If he's a government employee, even if the conviction is maintained, he may be in problem. Just check it up and tell. Yes.
31.
One my lord, I pray for a short admin. Taken up next week, my lord, I prepare a short note that it will be convenient.
It is conviction against conviction.
My lord's conviction under section 493 IPC.
493. And sentence?
My lord's 2 years RI, my lords.
2 years.
My lords.
Okay. Next is conviction.
Okay.
Prepare a
My lords.
note and come.
My lords.
32.
Well, before my lord takes 32, my learned friend has come with regards to item number 23. I have given him the Xerox copy of the draft as well as the earlier payment which was mailed to the complainant on 3/1/14. I have given the receipts.
1 lakh rupees you have taken. Take this 15,000 rupees and finish it up.
That was deposited, my lord, and before the learned SDGM. Yes.
That will be released.
Yes, my lordship, my dear.
That was 3/1/14.
Yes, 2014 it was deposited.
1 lakh.
1 lakh.
And 15,000 has been prepared in his name. My lord may take note of the draft.
Where is the draft? Where will you give the draft?
Tomorrow, my lord, if it is order reverse, I think complainant has not agreed. May that draft.
No, it has to be given.
It has been prepared after the order was passed by this court on 11th itself.
Yes. Yes.
Not that earlier.
Yesterday.
Yesterday only.
15,000. Huh? And the 1 lakh rupees deposited?
The receipt is there. my lord.
Last page.
I'll dispose it up. Huh? This is. I'll give a direction to release this amount in favor of the informant, complainant. Okay.
No,
It will
that
take-
15,000 has not been deposited in the court. After my lord will direct it, I will deposit it over.
I'll record your undertaking
Yes,
that
yes,
yes.
yes.
By tomorrow.
My
you
lord
will-
may record the bank draft number so
Right,
that.
huh. Right. They do. Yes. 32.
My lord. Here, the last occasion, a pertinent question was asked by my lord in the case of Prevention of Corruption Act, whether provisions of Probation of Offenders Act can be applied or not. No, my lord.
No, that's right.
It cannot be applied. And I have also verified the decisions that whether court can reduce the minimum sentence or not. Yes, it can be. So, now you don't know
Because this is a matter pending since 1996.
For example, my lord, here is a case 1995 volume 5 SCC 320. Section 5.
But Supreme Court under 482, under 142 can do what? I'm exercising revisional jurisdiction. How
Accused
can I do
sub-inspector
it?
of police. No, my lord. Consideration is occurrence take place 16 years back. Accused lost his job and a big family to support. Sentence reduced to already honorable.
That is
And in some cases, some fine has been imposed also.
142.
Yes. No, it cannot be 142. All 142 haba Supreme Court can say 142.
Do you have any judgment of High Court?
Our High Court. Or any court.
Any High Court?
My learned friend had got a decision, my lord, he was saying me on that day.
Misplaced it. I'm not getting that.
That
reference.
even Provision of Offenders Act has been extended by that court. But
that
my
is
conclusion is
valid part.
but my conclusion is it cannot be.
That
Because I also got a decision, it cannot be applied. That Supreme Court
if
judgment.
you can get some judgment of some High Court, then
I will see to it. Yes. So I was just searching for
because the
Supreme
Supreme Court under 142 they can do whatever.
Yes.
And a revisional jurisdiction, how the High Court can reduce the sentence when
whether
the
this
statute provides something.
whether this judgment of Supreme Court has been taken note of by any other High Court or not while considering case of PC Act. That I will see.
This PO Act can never be extended.
Provision of Offenders Act is not applicable.
There is judgment.
That has been ruled out.
It's a that has been ruled out in 2000, my lords, in the case of Boregowda versus State of Karnataka.
2000.
2000.
No, that has been ballot judgment is 2006 volume 11 SCC 473, where the High Court was 2006 volume 11 SCC 473 or 2007 volume 1 SCC criminal 520, wherein in paragraph it has been held section 18 of the Prevention of Offenders Act stipulated that it was applicable to offences punishable under 5(2) Prevention of Corruption Act's old act. Specific references was made, but ultimately let me see this document.
PC Act is not applicable.
No.
That's for sure. That is for sure.
But
And the check period is 1981 to 83.
Yes.
That time, this gentleman, petitioner, was about what is his name?
Kailash, my lords.
Kailash, na?
Now he will be around 80.
Kailash was 51 years in the year 1996.
Lord, verify the judgments, whether it has been taken note of.
So, what would be his age now? 51 years in
80
96.
How much
So
is
he
it?
must be about 90. 90, above 90.
That has been taken note of. The tension.
Nine.
Huh?
2000.
I'll see to it, madam.
I'll put it in 23rd.
Yes.
23rd. Because the idea is if you can, we can get some judgment, we can utilize that
Yes,
in
other cases also.
That is the idea.
Correct. Another case.
No chance of a good earlier.
32 and 33, both are same.
Okay.
Same.
Same point.
Same point.
PCI.
23rd.
23rd part of the Kharij part kar do?
Here there was a direction, it seems. The well-being and whereabout of the appellant not yet received from the SP Vigilance, Koraput, and soft copy of T-shirt. In both the matters, have you got the well-being and whereabout of?
My lord, I will check it because in between months the record has been misplaced somewhere.
My lord, item number 32, my lord and friend on the last occasion submitted that he was bedridden but he's alive. He is bedridden but he is alive.
Then it's
Yeah, that is, yeah.
And
Vigilance
33.
Cuttack.
Yes.
He is given the report.
Koraput.
But what about the other matter?
33.
33.
33, no instruction was there.
No, I have got the instructions. They were not able to trace him, my lords. They did a local inquiry.
So no instruction.
But
So
nobody was able to tell about the whereabouts. They have done that local inquiry on the specified address also, my lords.
I have also instructed the local lawyer who was conducting
Lordship,
the
may kindly
case,
see the instruction.
Ram Kumar, but he is also not getting him.
Please the map. They must have shifted from that place. That was the instruction that I have received. Lordship, kindly have a look at it.
What was his age during the 1980?
The migrant had got it in as around 50.
Let us see the
2001.
The statement, it was not there, but migrant got it.
Charge sheet in
33, na?
Yes, ma'am.
33. Let us see the charge sheet, na? What is his name?
Sindiri Ramakrishna Rao.
Sindiri Ramakrishna. He was 44 years old in the 1989.
It's a case of 87, madam.
79 presently.
79.
79 years.
79.
At address ballot, it has written as no such person in the address.
Yes.
It is written to sender.
What to do in these kind of cases?
Let them try.
If your lordship gives us some more time, we will take another attempt.
23rd also.
23rd month है पर one. Take out take some.
23rd also try the other matter.
Yes, we will try. We can give a try.
Right on Mr. Ijbil and counsel for the prisoner, opposite party state the belief that he would seek instruction from the SP Barampur, SP Vigilance.
Koraput Division, Jaipur.
Koraput Division, Jaipur, regarding the well-being and whereabout of the sole appellant by next date of hearing, release the matter on 23rd. Both the matter released in 23rd.
At
2 p.m. matter?
32 and 33, yes.
On 23 at 2 p.m.
Yes. 32 and 30.
Item 34. 34, my lord, this is a trap case. The total witnesses are 4, I think.
Yes.
Case under section 7 and
Then I'll put it in the weekly list.
Yes, ma'am.
Let's see.
Weekly list.
Yes.
Weekly list. Yes. 35.
35, 36 say बड़ा weekly
Weekly list करो.
Yes.
35, 36. 2006. What do you look for? 37. Huh? These are not similar matters, na?
No, my lords.
Yes.
No.
37. 37.
37.
Weekly is good. Oh,
Yes.
also.
2 p.m. দিতে পারি 82 আরম্ভ হবে
মানে এটা
Item 2
মন্ডে
I am there, my lords.
এটা মন্ডে আসছো ভাই না
Monday, no, item 3.
item 2 supplementary
That is Nityananda Naik.
Again. Yeah,
Nityananda Naik.
I'm recording another court, my lords.
But you have written item 3, that is the problem. Mr. Ponda has written item 3, so I was searching item 3.
I wish you happy weekend by now.
Now he has come under that pressure of weekend. Next week, no problem. Okay, next. Yes. Where is that? Yes.
I humbly pray your lordship can dispose it of this bail.
No, not dispose of.
But this is a fresh bail application and
1 minute. Interim bail, who had given you?
yes.
Let us
Honorable Justice MSO had given because he was sitting for that particular day only. But this is a fresh bail application.
fresh bail application, but it is before some other bench. I'll extend it.
My lord.
I'll extend it and list it. By the order dated 18/6/2024, the coordinate bench of this court had extended the concession for anticipatory bail.
My lord.
Interim concession bail until today, that is 12/7/2024. Therefore, this matter was mentioned before this court. In view of the urgency involved in this matter, the interim order dated 18/6/2024 is extended till next date of hearing.
Till the next.
Till next date of hearing, and list the matter before appropriate assignments.
Grateful.
Posted to lordship.
Till the
Next week. Leave this week. Next week.
My lord, till the next date will be approved because what happened in this
Till next date only, I'm saying.
till the next date.
Yes.
There are two anticipatory bills, 5867 and 5868.
And both the matters, huh?
My lord.
And both the matters.
My lord. Deeply obliged. Good.
List it. Okay. Okay. Supplementary item 10. 10.
Pass over.
Cancellation bill.
Madam, I'm sorry to say that the petition will challenge the order of the court below, court below. And the grounds he has taken 10 grounds, my lord.
On merits and merits.
On behalf of
What
Mr.
specifically, sir?
Mr. S.C. Mahathir, his counsel praying for time, or your lordship pass over it? In fact,
Hey, I have passed it over, but
It's
see,
not-
on merit he is challenging it. This is not the court. You have to go to.
The government he has taken, that will be deciding a court bill. Because but the condition he has followed.
Only on merit he is saying that this order should be recalled.
Yes.
And merit I can't go into because they have to go to Supreme Court for challenging it.
Since Master is praying for time, not available. One day. The absence of Mr. S.C. Mahathir, senior advocate.
ठीक है मंडे पे
हाँ,
करो।
Monday. ये छोटा केस।
हाँ ठीक है मंडे करो कोई बात नहीं 2 मिनट लग जाएगा वो डिसमिस करना है कुछ है ही नहीं उसमें। बात वही come to weekly
Weekly item 82.
82 yes
I have 5 revision applications, Lordship.
Hmm.
And I would like to pray your Lordship for 82 is concerned, that may take us some other day and others may can be taken up. Sorry? 82 item is concerned. It may be taken up, your Lordship, 1 week after any day, your Lordship, date may can be fixed. And so far others are concerned, that is 86, 88. There are 4 revision petitions. That may can be taken up.
नहीं 82 you
82
don't want to do
आज कौन परिपारी में आउट देना पड़ी
82 let it be there in the list huh? Forget it 83
more number 86 88
86 and
88
86 yes
86 is 130 day enacted lordship
you are accused
willing to lordship refund the amount. I have a judgment also this court and bench pass kind of there what has been done
who is appearing for the opposite party number 2 nobody anyway what do you want
this is the judgment lordship I'm supplying also a glance where this one could what did lordship they set aside the sentence lordship and given 4 more times so far the accused is concerned to pay the check and compensation amount. If not paid, then the sentence and the conviction will run accordingly as has been passed by the tribunal. And that has been specifically mentioned in the paragraph, page 3, paragraph 3 years. Consider the submission made in the fact and submission while conferring the finding of conviction. The revision stand disposed by setting the order of sentence of simple judgment for a period of 1 year and fixing the quantum of compensation 1,50,000 to be paid by the accused to the complainant within a period of 4 months from today. And in default of payment of the same, he would undergo simple judgment for a period of 6 months, as has been passed by the trial court and appellate court also. So if you lordship 4 month time will be given to me, lordship, I am ready to deposit the amount, lordship.
have you deposited 25%?
Yeah, that has been complied. 1 lakh rupees, your lordship, has already been deposited. And the petition has also been filed by the opposite party complainant. The amount has already been released in view of the order passed by this court in his favor. He has taken away the 1 lakh rupees.
1 lakh. What is the check amount?
The check amount of 2,75,000 lordship. And now award is lordship 3 lakhs. I remain only to pay your lordship 2,75,000.
Though in this judgment, the court says that the
court says that-
imprisoned part goes.
Yes.
Sentence, the compensation part remains.
Limits. And if failure to make payment of the settlement within the 4th month given by this one, Then as usual, the conviction sentence passed by the London court will be.
That will revive.
Yes, my lord. I feel it will be better, your lordship, the maximum revision case will be quashed, because 130 day enacted, lordship.
Yes.
Money has to be paid, your lordship. And
Ultimately.
they are asking for time.
And the problem is again, extension application will be moved.
That may be sometime arise, your lordship, that it can depend upon consent of the parties if it may be extended, cannot be extended. But I think it may not be. But I have taken, your lordship, maximum cases out of this, like, and everybody has been compliant, your lordship. They paid the money and.
So you say, what is the, in your case, this case, what do you say? What is the check amount?
The check amount will also 2,75,000.
And
The award will also 3 lakh.
3 lakh.
3 lakh.
And the sentence?
Sentence will also 6 months.
6 months.
Yes, my lord. And I have already been paid, your lordship, 1 lakh rupees in view of the direction given by this one court, your lordship.
1 lakh. Huh? Give me the file. Give me the file. When you paid 1 lakh? To me, when have you paid 1 lakh?
My lord?
1 lakh rupees.
Yes, my lord.
Pursuant to the order
Order
dated
9/3/2023 order, your lordship, may kindly glance.
Yes.
1 lakh rupees be released in favor of the opposition to put up this matter after summer vacation.
Okay. 1 lakh rupees you have paid, and remaining you will pay within 4 months. Okay.
It may be disposed on that light.
This matter and
your lordship 88 ର 3ଟା item ଅଛି.
No, you tell me what is the cost title? Where is the cost title?
Download करे आदिकंत पर देई दउछे.
And cost title बाहर पड़ियो.
Cost title बाहर कर आदिकंत पर versus
এটা উঠে দিয়ে দেবো. Next item is
88 आएगा.
88.
3টা ଅଛି.
88.
Yeah.
What is the sentence here?
I am coming, your lordship. Suppose 6 months. Here check amount, your lordship, 12 lakh.
88.
Yes, my lord. Check amount 12 lakh. Award 13 lakh. Out of which I have already paid rupees 1 lakh before the court below.
File done. 88.
Award 28 तो serial कर दी तो.
3টা. 88, there are 3 matters.
Yes, my lord. I am holding so far criminal 813/2020.
813. Yes. How much you have paid? Check amount.
Yes, my lord. Here, your lordship, the check amount is 12 lakh. And the award, your lordship, 13 lakh. Out of which, in view of the direction, also already, your lordship, deposit rupees 1 lakh before the court bill and religion bill in course of appeal, your lordship.
During appeal?
Yes, my lord.
1 lakh rupees here.
And rest of the amount, your lordship, I would like to pay the same. This automatic.
Sentence?
Sentence, your lordship.
Hmm. Four months. All right.
Yes, my lord.
13,92,000.
13,92,000.
Yes, this is also done. Next.
Next, 467 of 2018, my lords.
No. Huh?
Criminal division 814/2013.
814.
Yes,
yes. Here. You tell me.
Here, your lordship, 3,77,000. 3,77,000.
How much you have deposited?
25,000 loss. I have deposited 25,000 loss.
Already deposited?
Yes, my lord.
Where is that? Where is that? Where is that? 3,20,000 compensation is 3,20,000. Isn't it? 3,20,000. Where have you deposited that? Where is the order of depositing?
Is the judgment will have a glance, is a judgment 29/7/2013.
Huh? 20?
29/7/2013 of the additional sessions of Barampur also. And the trial court judgment also 18/4/2012.
No, you deposit, the deposit which you.
This is before the court below also, not here.
Court below.
Yes, when the appeal lordship there is a condition precedent to deposit the amount.
In the appeal stage.
Yes, my lord.
25%.
25,000 deposit lords.
25,000 deposit.
Deposited, as I instructed.
25,000 not deposited.
Tala court.
25,000 had not been. I am clarifying matter. This honorable court while issuing notice in.
No, no, it. Tab second 814 ରୁ କୁହନ୍ତୁ.
What I am proposing to do is, whatever the compensation amount is there, whatever he has deposited, the rest amount I am giving 4 months time to deposit. If he doesn't deposit, the entire sentence will revive. It fails. Otherwise, 4 months this matter will be lying unnecessary. You get back your money.
I pray one thing, my lord.
Huh.
I concede with my lord. My lord may grant 4 weeks, 4 months time. But instead of 4 months, my lord may specify the date. After 4 months, I leave it to my lord.
Okay, that's
Not
the
necessary.
same thing. 4 months.
No, because
Honor before.
Honor before 4 months, your lordship. No, date, particular date may be fixed.
You tell me after 4 months count now. From what is the date today?
Today is 12th.
12th, I think it is 15th. Okay. 15th, today is 15th, suppose.
12th July.
August, September, October,
October.
November. 15th November.
15th.
Finish.
Honor before 15th November.
15th November.
Honor before 15th. If you will not deposit,
automatically.
Another thing, my lord.
Same thing he is telling in English. That's all. Same thing he is telling in English.
I am speaking Odia.
You tell me this matter. How much we deposited? All?
My lord, what?
814.
My lord, first 813, my lord came.
800
One by one, I am clarifying.
814, 813, he has deposited 1 lakh rupees.
Oh, 813?
Yes.
He has deposited rupees 1 lakh. I have already received that 1 lakh.
Okay, you have received. I am not saying anything. You have received enough.
And
the remaining amount within 4. Honor before.
No, the remaining amount he has not deposited.
4 months I am giving. Honor before 15th November 2024. Okay.
A compensation amount.
That compensation amount only I am talking about. Why are you complicating?
Because of the
NDPS case for the border case to argue korthule guda paisa patra pai.
He is still under the hangover of that death sentence. He said that in this matter also, death sentence should be imposed.
Man, I may pardon. I am asking. The award amount is 813. Clarifying.
No, not to be clarified, I have seen it. Come to 14.
814.
Yes. How much already have been deposited? You tell.
My lord, as per my instruction, only 25,000.
Yes, that's what he says.
25,000 deposited, but the claimant has not withdrawn. My lord will direct the claimant to withdraw now.
Can you tell me when it was deposited?
My lord, after the revisional order was passed.
After?
The revisional order was passed.
No, not revision. It is after the appeal. During appeal stage.
Revision order to deposit the entire amount. Revision order my
revision so far when I release on bail by the court, appellate court orders, by that time I deposited 25,000. Admittedly 25,000 deposited they are your lordship. They are admitting I am it.
25,000 deposited.
Yes, but my lord will directly my lord will directly claimant to withdraw that up.
Yes, yes.
That line we add.
I'll pass a general order. If you have not withdrawn, it will be disbursed to you. If not disbursed.
Then your lordship next 815. 3,54,000. 4 months are
3 lakhs, na?
3,54,000. 25,000 deposit.
25 deposit.
Aye.
And 25 deposit. Appellate stage, huh?
Yes, ma'am.
Acha. ठीक है.
But in this case, in 8 and 15, 8 and 15, my lord may say the legal heads of the complainant. Because in the meantime, complaint has expired.
Yes, they have not been implemented a party, let them implement. They are here also, not here.
No, no, no. My lord may observe that. I
Died when?
My lord?
Respondent died when?
That's what you want.
ସବୁ last Sunday
આપણે
ମଗେଇ
discuss file କରିଦେଲେନି?
You tell me. ଏଠି ଯାଇକି dispose କଲା ବେଳକୁ କରିବି
Correct.
ଆପଣ
They, what
ଏଇଠି
person
ତ ଖତମ.
raise the question there.
My lord, my lord.
Lordship may observe it.
My lord, this book died on Dr. Bharat Kumar Patnaik expired on 21/5/2017.
21/5?
2017.
2017.
My lord.
ठीक है. It will be disbursed to the LRs आपको.
Yes, ma'am. Yes, ma'am.
ठीक है.
I am cooperating my lord friend, how we collect the money immediately.
No.
Idea is to get back the money.
Yes.
That's the idea. Yes.
Obligation.
All the four.
All the three, ma'am.
ଆପଣ ନିଅନ୍ତି judgment କରି
Four.
ଆପଣଙ୍କର ଯଦି କୋଉଠି ଥିବ
Four
ଆପଣ
matters.
କରିକି ଦେଖେଇନି।
ଏଠି ଦେଇଦିଅ four matters ability. ନହେଲେ ରହିଯାଉ. Huh? Order क्या reserve? छोड़ दो ना dispose of all. Huh? No, don't reserve. I am not reserving. I'm part.
Yes, yes, my lord.
addicted right
Yes,
now.
my lord. Yes,
Yes.
Duly obliged, lords.
Yes. Thank you.
Deeply obliged, my lord.
89.
89 and 87 therefore 89 sorry 85 sorry 85 yes sir 85
My lord, this is a revision against the order passed in refusing my prayer there in the appellate court to adduce additional evidence, my lord.
additional evidence
Yes. My lord,
was there any stay before this court?
yes.
Stay was going operating.
This court,
Trial court proceeding was stayed.
trial court, appellate court.
In the appellate court, you wanted to lead additional evidence, which was rejected.
Additional
The
evidence.
appeal is still pending.
That is pending.
Yes.
The case is like this, my lord.
Show me the application which you moved.
Pardon?
Which application is rejected?
The application has been filed and that has been rejected by order dated 27/11/2012, my lord. And next year, it has been
37 A of air
Yes,
pollution
my lord.
control.
In criminal appeal 34 of 2011, my petition has been disposed of on 27/11/2012. There, my prayer has been rejected. So I am there before this.
Now, where is that application?
Application copy has not been filed, I think, along with this revision.
Where is that application? Application is not there. Where is that order also not there? Where is the impugn order?
Impugn order is there, my lord. With the record, my lord. 27/11/2012 रे अछि. Criminal appeal 34 of 2011.
Look at complainant board. What do you want to lead?
Yes, my lord, the things is like this. I have a brick lane and I was, as per the prosecution, without necessary sanction, I was operating the brick lane. So for that purpose, I violated the provision under 17(2), section 17 and
47.
sorry, section 21 and section 31A. But because I want to place certain documents before the court that I have applied for the sanction and they slept over the matter. And till this case has been filed,
But the fact remains that you had no license.
yes, I do have the license. I do have the license, but after this pollution control act has come into play, we have to operate the brick lane after getting necessary sanction from the authority concerned.
Okay, but there was no sanction as such. You had applied it, they have not.
They have not either
given
refused
the
it or
That
gave
means
it.
you can apply without sanction, you can carry on.
No.
Offense is without the sanction.
Yes, ma'am.
You have done it.
Yes.
Okay. Causing environment hazard.
My lord.
That's the case. You said that I have applied for it and they slept over.
Yes.
How does it give defense to you?
That the provision.
That may be negligence.
21(4) specifically says, if I will apply for a sanction, they have to grant it within 4 months or has to refuse. But then your
that is a separate consequence. If they don't do it, you prosecute them, whatever you want to do, proceed against them.
Yes.
But will they give you license to, carry on without sanction? Sanction is mandatory. They haven't done it, it's a different story. But the fact remains that on the day you were running the brick lane, that day sanction was not there.
Before this act come into play, I have applied for the sanction. And they slept over the matter. And for that purpose, this honorable court has directed the authority concerned not
to... You show me where are the evidence you led in show me 131, 313 statement. Have you said there that I have applied?
Millard, there I have brought into record one coming.
85, no? Item? 85. You show me under 313, your statement, you have said that I have applied for it.
Millard, I am drawing the attention of the
Actually, things is that he has a moving chimney. 2002 Supreme Court.
Issue is something different. Issue
No,
says that he wanted to lead some evidence.
But
the evidence,
evidence
he
is
had
that
applied for sanction. It was lying there, and meanwhile the raid has taken place.
Lordship, it cannot be. Here, moving chimney cannot be converted into fixed chimney. Fixed chimney is the project is separate. Moving chimney, simple, they will make the bricks and they will fire it. But in fixed chimney,
you are going. His attack is something else. What he says something else. This is not against the conviction. He says that he moved an application for leading additional evidence.
obviously he has given application.
And he can lead the defense evidence subject to condition that he has taken that ground in the 313. Very 313. Have you said that? These are not read petitions. Have you suggested the IO that I have
taken the stand in the court below that
what stand on the have you proposed it? Have you given the suggestion to the witness?
Yes,
official witness.
Yes,
show me that.
Yes, your lordship.
Show me that.
I have given suggestion to him that for passing the order for which I have been convicted, I have approached this honorable court in filing WPC number 13848 of 2003, and the lordship being pleased directed that my brick lane cannot be demolished. And it was the order of the authority has been stayed. That the very thing has been put to the witness in question.
Where is that? Show me.
That order is not with me.
That is the long and short of that matter. If you have put those suggestions under your statement under 313, you have said that I had applied for it, then only you can be given an option of leading additional evidence. Otherwise, you can't create a fresh evidence in the appellate stage.
No. It is already I have put like this, my lord, at para 8 of the witness prosecution that WPC number 13848 of 2003 was communicated to me. And I cannot say without verifying the documents from the office that whether it was ascertained from the collector and sub-collector regarding the execution of direction of the bill. And again, he has stated in para 9 that I cannot say without verifying the record that the brick clean of accused belong to which Mahuja, that is different. And he was a party in that WPC. This witness, that has been also put to him, that you have given necessary affidavit.
I will dispose of your revision petition, observing that whatever you have urged before this court shall be taken into consideration at the time of disposal of your appeal.
Yes.
That is my point.
That's what I'm going to dispose it up with an observation that whatever you have urged in this petition shall be considered at the time of hearing of the appeal.
That is my point, my lord. During the course of appeal, I want to place certain documents of the government.
I will make that observation and dispose it up. I can do that.
Yes.
Whatever contention he has raised in this revision petition, these are kept open to be heard by the appellate court and take the call as the final.
Yes, sir.
Yes, Mr. Rangada, what do you say?
What happened, madam? Here, I'll give 90%, madam. I'll put, madam, rejected on the ground that which document they have cited, that is no relevance with the
court will decide at the final stage.
Yes,
Final stage. Madam, in the present revision petition, petitioner has challenged the order dated. Right, that's the whole difficulty. No, in the prayer, nothing is written. Which order?
Order passed on.
Order dated 27/11/2012. Order dated passed by.
Appellate court in criminal appeal number 34 of 2011.
Passed by.
The appellate court.
Nah, you have to tell the name of the
court. Additional. It is lying.
You don't write anything. Where from I'll get on?
Yes, I'm telling you. This is a past.
Sessions there.
additional sessions.
Additional sessions.
Cuttack.
Second additional sessions Cuttack in criminal appeal number 34 of 2011, whereby the application moved by the petitioner under section 391 CRPC to adduce additional documentary evidence at the appellate stage has been rejected. Counsel for the petitioner submits that he intended to place on record certain documents in his defense. However, the appellate court in the impugn order the appellate court has rejected the prayer on the inter alia, stating that the documents are not relevant for the purpose of deciding the appeal. Agreed by the said impugn judgment, impugn order passed by the appellate court. The present revision is filed. At this stage, this court is not inclined to go into the merits of the case. Therefore, the petition is disposed of with a liberty to the petitioner to raise all the points raised urged in this revision petition before the appellate court, at the time of final decision. If the appellate court is also directed to take into consideration the plea raised by the petitioners hearing at the time of disposal of the appeal. With this observation, the petition is disposed. Yes. You will take into consideration your yes. Next.
87.
Yes.
May it please allow speak. As a amicus in this matter.
Yes. Sir?
Then certified copy might be passed.
That. Paperwork. You don't have paperwork.
My lord?
You don't have file.
No, my lord.
You forgot your file.
No, I have not accepted that file, my lord, because previously in this matter, my lord, the counsel appeared and he said, I will continue the matter.
Yes,
and he take the brief along with him.
I do one thing then. I will direct them to give a copy to you.
My lord.
The registry is directed to supply a copy of the available papers in the present case to Mr. T.K. Sahu, advocate who has been appointed as a amicus curiae within 2 days. Leave the matter.
Monday.
And let it be there.
Well,
Let it be there in the weekly list. Retain it weekly. Okay.
gratefully. Your Worship.
By tomorrow, receive will die. Yes. 89. '89. 89. This matter was lastly revision in 2014. Against conviction.
Yes.
Conviction. These are चलो आगे चलो देखते हैं 90
Posted to next week.
it will remain like this 90 this is also against conviction
Those are interested about the.
just against interim order or anything. If you see those who are interested, then none of them will be interested.
My serial also was sitting here.
Yes. Yes, tell me then. Yes, tell me which matter. you are there.
154.
We can
154.
54.
Serial number.
Sir, you?
97.
97.
But
facile thing.
but Mr. Das said that it will not reach. He went away for vigilance. I am sitting here.
Now let it be there.
Okay,
Let it be
my
there.
lord.
Yes.
A small matter.
Yes. 154.
My lord, my lord.
Yes.
May it please, my lord.
Yes.
My lord, the offence alleged to have been committed by the petitioner is under section 224 IPC. That means escaping from the police custody, judicial custody. My lord, the petitioner was apprehended while jumping bail in a criminal case, that is GR case number 190 of 1998. And he was brought to the court by two constables. And this is formality when they came and to take the accused to the jail, then he allegations that when we tried to handcuff him, he pushed us and went away. Ran away. My lord, to that there are also prevarications with regard to timing, and some said it is 6:30, some said 7:30. And the accused case is that he was not.
You were in custody in which case? Another case.
I was, he was brought, he was apprehended in that case and brought to the.
No, which case? What are the
GR case number 341, 324, 294, 5. That case has already been ended.
Acquitted.
Yes, madam. That is ended. That is my case. And the learned trial court has
How many
convicted.
cases do you have against you?
That is the only case. That was the only case between the some family members also. That has been ended. And the learned trial court has convicted the petitioner for 6 months. Simple. Right. And that was also confirmed by the learned sessions judge. So I got bail from this honorable court. He was convicted. The learned trial court said, I feel that the convict deserves some leniency while awarding sentence. So I sentenced the convict to undergo rigorous imprisonment.
Are you sure that you are surviving today?
I am surviving. He has become old, but he is there. He is there. I could contact him.
2012, he was 63.
He was old by then, but he is living because I contacted him with through the London Council who was appearing for him, his leave.
The incident is of 1999.
Yes, my lord. Yes.
Why?
He was also some
And
period.
he also remained 2 months. Custody.
2 months in custody.
Yes, my lord, the conviction, and I got him bail from this honorable court.
You tell me from custody 2 months.
Exact date I don't remember because that is not reflected here in my. But he was convicted by the London Trial Court, and while sentencing him, London Trial Court said that I sentenced the convict to undergo rigorous imprisonment for 6 months for offence under Section 224. The period undergone as UTP be set up. So for some period he has gone there, and my lord, the London Sessions has convicted him on 19/12/2012. 19/12/2012. And this honorable court granted bail on 10/12/2012.
Only 9, how many days?
Sorry, 12/9/2012. The conviction was by the London High.
9.
September conviction hela, eti mo bail heichi
1
December.
month.
December bail heichi.
December 1, no, 2 months.
Yes, madam. Yes.
2 months. And during
UTP also
trial
he was.
UTP means
Some period he must have been
10,
there.
15 days maybe.
Maybe. Court hai. High Court hai na.
Trial court says that the accused be taken to custody to serve out the.
And in this case, my lord, can see order dated in the present 10/12/22. 12. 10/12/12. The petitioner has been convicted for the offence. This only in criminal division, sentenced to undergo arrest for 6 months, and which has been confirmed by the appellate by the additional session judge Baribada. It is stated that the petitioner has already been taken into custody.
That's what he says. He says that he was taken into custody on 12/9/2012.
No, that was the
date of conviction.
Date of
Because
conviction.
the order also says
Yes,
to be
ma'am.
taken into custody. And he was granted bail on 10/12/2000, means about 2 months he has already undergone. 2 months. And during trial also for some time. So more than 2 months. Already undergone,
The punishment prescribed may extend to 2 years and fine.
already undergone 73-year man. Why unless
And he has already acquitted from the main case.
I will not go into all these things. I'll
Fine.
say that I am confining this revision petition only to the quantum of sentence and sentence already undergone, finish.
Obliged.
Why? Because looking into his age and
Obliged.
incident is of 1999 and what?
These type of small cases are not more.
It will be then custody. Custody, yeah. Custody. During. Right. Also. Yes.
105.
105. Yes. Yes.
Madam. 376, madam.
Kalia.
Case of 376.
It needs hearing.
Needs hearing.
Wait. I just want to go through the weekly list today being Friday. Small matter I can hearing matter leisurely.
List ରହିବ
List ରହିବ କିଛି Small matter which can be disposed of here. Come to next. 90. Just see, Mr. Garuda, 90.
116.
Small matter?
Small matter. So conviction under section 324, 323. PO Act land disputes. Previous enmities were there.
Incident?
Incident is 2001.
Sentence?
Sentence my lord.
2000, item number?
116.
116. 116.
RI for 6 months for the offense 354 IPC. RI for 1 year for the offense 324 IPC. Undergo RI for 3 months for the offense 323 IPC.
How much you have undergone?
Undergone.
Find out undergone period.
ମାନେ ଯଦିଓ ଟିକେ ଫାଷ୍ଟ ପାର୍ଟ ସେଟାରେ ଯୋଉଟାରେ ଏସଟିଜେଏମ କୋର୍ଟର ଫରୱାର୍ଡ
You just find out undergone part, we'll see.
Malad.
Otherwise,
Malad.
already undergone.
Malad.
Yes. This is 90, yeah? 90, 90, what happened? 90? Nobody's there. Conviction.
Conviction, all matters.
90, okay, sir. 91. 91. Two 2014. Come, old matters come to 99. Anybody is at 99? 2011 matter. You are there?
95, matter.
95.
Let it liable, matter. Next week, matter. Mr. Das will argue matter.
2014. Oh, let it be. Let it be there, no problem. I'm just targeting the old matters. 99 is 2011 matter. Let's see what is this case is about. Conviction.
Private case.
Oh, 408. छोड़ो आगे आओ 90 100 100. Next time when you weekly year wise you have to do it, not that 2019 matter is coming up fast, thereafter 11. No, a weekly list, why can't they put it in the here? Which one? These are
Up to 98 matter there.
From 99 it's
Hearing matters.
90?
99
Starting from 99.
hearing matters.
So this is 100. Item 100 is not admitted so far.
No, admit is no. 89 पर LCR करिए admit age. Prime maximum.
Nobody is interested.
83 also admitted. 82 also admitted. The hearing is second. 95 also admitted.
Yes, now 100.
101.
Did you 3 years same?
You are supposed to give
Regular hearing.
written submission, not given. Yes. And 2.
102.
498, 323. 3 years.
Parties have settled their dispute. He wants to move an appropriate application and affidavit within a week. Service for Vera. What to do these kind of matters?
Mr. How is there, my lord, you can engage an amicus
No, he says, this matter he has said that we have settled the dispute and
My
filed
lord.
the affidavit.
My lord.
Thereafter, it's 498A. There you have already. We can put it in the supplementary.
So
This,
that
this matter put it in supplementary. Wait, there are many matters. If nobody is there, 103.
103.
En masse, we have to do something. Otherwise, there is no end to it. Huh? LCR not ready. Chodo, next.
104. 103 LCR may be called for.
Yeah, it's already called for. 104.
376, my lord. Needs regular here.
104, huh?
7 years comes. 376.
104.
104.
Na?
376.
105.
The 376, my lord.
105 also.
My lord. Just now, my lord, he mentioned. Honorable President. Thank you.
Yes, next.
106.
What do we? These people are not coming.
92 factory jack. Say for 6 months.
Dear Nando.
Little, I will inform.
Mr. Dear Nando. Short time last. Please inform. Next. 100.
106.
Actually, in our list, if how much has been adjusted from the weekly and from where it will start, it would have written, all would have come here. Otherwise, they are thinking that a weekly there. How they will
may
look
not
that?
reach.
Yes, they are not able to know.
Late.
108.
Devashish Mishra appointed as
Amicus
amicus curiae.
Convention under section 450 to 324. 2 years.
Devashish Mishra, where is he?
Short. This case
108.
may be disposed of, Mr. Shah will argue and discuss it, so that some cases will dispose of.
That is the idea.
My lord.
If the
Yes, you know.
one amicus curiae appointed, yeah, that's the whole difficulty here. See, we should not appoint someone as amicus curiae who is not assisting. What is the use of amicus curiae? You should be,
On the other day, he
you
was
behave the same manner in which the councils are appearing. What is?
Madam, I may pardon. In one case, in death reference case, I have been appointed amicus curiae. Leaving all the courts, I have remaining there.
You are getting everything from the system, from the court, and you have to give it back also. It's not always that you should expect that you get.
One should give respect to the court order and should
Always
remain
cases,
present.
see, these are the matters, 2011 matters. Nobody is coming forward to do. See, this matter 2009 revision. Nobody appears from the matter, When lease the matter on such and such a I'm saying, if the petitioners are not appearing, why don't you write none appear? You write the name. Mr. Idas appearing. How do you know whether they have appeared or not?
$108, my lord, conviction under 452, 324. Appellate court, the trial court committed him, sentenced him 2 years imprisonment and fine 500. But the appellate court, my lord, reduced the sentence 2 years to 1 year.
In
And fine 500.
110. Huh?
No, 108.
And 110 you come to 110. 350, na?
110, 750.
Yes. Mr. Sahu, this matter you see last year, last hearing thereafter before nobody appeared. So the metro was listed earlier on many occasions, and lastly it was listed on 9/4/2024. None appeared for the petitioner. In view of the same, Mr. T.K. Sahu, who is present in the court, is appointed as a amicus curiae to assist the court. Race is directed to supply a copy of the copy of a paperwork, existing paperwork to Mr. Sahu. Please the matter. You tell me.
It's huh? Just can dispose of, my lord. What happened in this case, my lord?
Yes.
Conviction under section 25 Arms Act only. And sent SI for 1 year.
Recovery?
And 5,000, my lord.
Just see the recovery.
My lord.
Is there any recovery? Just give the file to him. Give the file to him. He is expert. He is working in the best possible office, criminal side. Mr. Sori Mahapatra is one of the best trial lawyers, and he works associated with him.
My lord, if your lordship allow me 5 minutes.
Yes. I'll just go through, just see recovery only.
Recovery gone, my lord.
Huh?
Gone as with recover.
Prove.
My lord. That I didn't prove, my lord. You with without license, my lord. For that, both the courts, my lord, confirm the judgment, my lord. 1 year conviction. You are clear.
No, arms act, whether you can be given.
Oh, my lord. Can. Only, my lord, 25 Arms Act. No other conviction. 25 1B. Yes.
Including the next weekly list. Mr. Sahu, get ready next Monday, Tuesday, you can do it. And only address me on the aspect that the provision of offenders can be extended in the offenses where somebody is involved in
Arms Act.
Arms Act. That will help in other matters. Otherwise, you can dispose it up. But see, en masse we are giving the benefit of provision of offenders. There are some restrictions also.
Some cases, my lord.
What in which kind of cases we can't give? Just have a look over that and give an idea. In which case we should give, like Prevention of Corruption Act, we can't give, no problem.
And also,
but there are many cases. The Supreme Court says that in 304A also you don't give, because it has become a menace. And the Arms Act, these are the desi katta, whatever is recovered. In these kind of cases, whether we should extend the benefit or not. If we can't extend the benefit, then it is better that to concentrate on acquittal if possible. Otherwise, reduce the sentence if possible. Yes.
When I pardon 116, LCR is not there. I will verify. Let it come on Tuesday. I have taken.
It will remain there. Don't worry.
I am leaving, madam. In court number 5, one matter I have mentioned.
Yes, of course.
On Tuesday, I play 116 on Tuesday.
No problem.
116 Tuesday.
Yes.
Tuesday.
Yes.
116 Tuesday. ମୁଁ ରେକର୍ଡଟା ଦେଖି ଖାଲି କହିଦେବି କେତେ ଦିନ ଭିତରେ ରହିଛି। Obliged to.
111. For 57, 392, 397. 7 years imprisonment, my lord, needs, my lord.
Non-APS. Matter is ready for hearing. Retain it. Proceeding so that next time we can appoint someone. Yes. Next.
112. Here, my lord, 452, 323, 324, 354, 506. RI for 2 years.
Non-AP is for the petitioner. Matter is ready for Hearing. Retaining. Okay. Je non-appear hoji karo. Yes.
113.
113, 323, 294, 506, 6 months, 1 month, 506, 1 year, 307, 5 years, and other points are there.
Non-appears, huh? For the same auto. 14.
114.
But here commissioners are 393, 2 years RI.
Non-appears. So least ରହିବ କିନ୍ତୁ non-appears.
115.
15 my lord, 392, RI for 1 year.
Non-appears.
And 16 also adjourned.
117.
Commission clause, and there are
376 million and 7 years with fine 20,000 million. With fine 20,000 million.
Non-appears.
118.
Million 436 million. RI 2 year fine 1,000.
Non-appears for the
119.
total get total get
Million 376 million 7 years and 2,000 fine million.
Otherwise, you can't keep on calling. Is anybody there who want to do his matter? 200 matters, you can't keep on calling and preparing. Non-appears separate. Mr. Raghunath, just see which are against interim orders or anything. Revision against some charge kind of.
All the matters are conviction.
All conviction.
All conviction.
Nothing against charge. Yes. Yes.
But I have got a matter about that matter related to vigilance. Council is now.
They are scared of you.
No, sir. In fact, not here.
Now we have to find out some way out in the sense, vigilance matter in the morning or revision matters in the morning, vigilance matter in the afternoon, something of that sort.
That's
Otherwise,
in
see,
that's why
there is no point whole day these people are waiting. It's not coming. Their time is also.
First hour manner all the criminal.
My lord, ultimately,
Except vigilance matter manner after lunch.
most of cases will be my lord will be disposed of, my lord.
So therefore, let us find out some way next week.
ଯଦି ବି କେହି ନ ଆସିବ,
Morning hour only the revisions and all, and after 2 o'clock.
Vigilance matters.
So they will also have free hand. They can.
Yes,
All
yes,
other
yes.
work they'll come here.
Yes. They will be pinpointed and everything will be there.
We'll work it out.
Yes.
Any mentioning? No. Look, thank you. The daily.
Correct.